Good morning. My name is Tom Cameron. I'm the Vice Chair of the Michigan Judicial Tenure Commission. Pursuant to MCR 9.241, the Commission is conducting a public hearing in the matter of the formal complaint number 106 in re Debra Nance, a judge of the 46th District Court in the city of Southfield, Oakland County, Michigan. The other members of the Commission are standing toward my right. The other members of the commission are starting toward my right. The audience's left is Judge Monty Brewmeister, Judge of Crawford County Probate Court. Dr. Maxine Hankins-Kane, one of the two civilian members of the commission that is neither an attorney nor a judge. Siham Jafar, one of the other civilian members of the commission who was appointed by Governor Gretchen Whitmer, as was Dr. Kane. Dawn Eisen, elected by the State Bar of Michigan. Judge Lillard, Judge of the Third Circuit Court. Judge Brian Sullivan, Judge also of the Third Circuit Court. We have two commissioners who are recused from this particular proceeding and will not be participating. That is Judge Pablo Cortez, Judge of the 62nd A District Court in Wyoming, Kent County, and Mr. Thomas Ryan, the chairperson of the commission, who is elected by the members of the State Bar of Michigan. We are now ready to proceed to the hearing. The record should reflect that the disciplinary co-counsel, Nicolette Horde, is participating, as is disciplinary co-counsel Glenn Page. The respondent, Judge Nance, is participating as respondent and co-counsel, along with her attorneys, Nicholas Serrano, thank you, and Michael Cafferty. By way of background, on December 14th, 2022, the commission issued formal complaint number 106 as to respondent Judge Nance, filed on answer on January 9th, 2023. The Supreme Court appointed Judge Alexander Lipsey, a retired Kalamazoo Circuit Court judge, to hear the evidence. A public evidentiary hearing was held over 6 days in June and July of 2025. The master issued his report pursuant to MCR 9.236 on October 14th, 2025. Each party filed briefs addressing the report. Today is the date and time set for the public oral argument on the objections pursuant to MCR 9.241. The commission will refrain from asking any questions during oral argument until I inquire from each commissioner if he or she has any questions. Each side will have 30 minutes to argue the case. We have a timer here, and I will do my best to keep track of time. I will let you know when you have 5 minutes left in your argument if you decide to reserve any time. Disciplinary counsel has the burden of proof, so you will have the opportunity to argue first. If you wish to reserve time for rebuttal, please let me know at the beginning of your argument and how much time you would like to reserve. So with that, Ms. Horde, go right ahead.
Thank you. May it please the commission, I would like to reserve whatever time I have left for rebuttal.
Go right ahead.
Disciplinary counsel appear before you to request that you recommend the removal of Judge Debra Nance from judicial office. This case, stripped to its core, is not about a bicycle rental dispute. It is not about a misunderstanding on Mackinac Island. It is not about imperfect memory. This case is about lying under oath repeatedly. It is about a sitting judge who, under oath before this commission, knowingly denied facts that, as it turned out, were captured on video and whose story has continued to evolve, retract, shift, and reshape itself over 6 years. The charges against Judge Nance arise from her sworn statement in July of 2020. Since that statement, her subsequent written responses and testimony at the public hearing are evidence of her continued misrepresentations and distortions of truth. The evidence demonstrates that Judge Nance falsely denied that she or Judge Brew told anyone that they were judges, that she denied that Judge Brew accused Mr. Green of assault, that she falsely denied that Judge Brew infused race into the Mackinac Island interaction, that she falsely claimed that Officer Hardy refused to even speak with them, even though he spoke with them for over 10 minutes. She did this to support her claim that Judge Brew never falsely told Officer Hardy that Mr. Green had assaulted her. And finally, she falsely claimed that she was told to wait by the curb in a racially demeaning manner. Later, Judge Nance altered those claims repeatedly. The video evidence and testimony refute every one of her claims. Yet despite the weight of the evidence that showed that Judge Nance was lying, and even though Judge Nance repeatedly changed her story, the neutral found that she did not make any knowingly false representations. Her false statements as charged in count 1 of the complaint were no accident. They cannot be blamed on an innocent misrecollection due to the passage of time. The tenor of Judge Nance's July 20th sworn statement makes very clear that she had a strong memory of the events. It is very important to note that the sworn testimony was given 1 year after the incident, the closest in time to the events, giving her the greatest possibility of recall. During her statement, she portrayed herself as very indignant about the way that Officer Hardy and Green had supposedly treated her and Judge Brew. She gave emphatic statements about what did and did not happen. She volunteered her most flagrantly false statements. She was not asked to summon them from her memory. Instead, she wanted to make sure that they were heard. And her false statements were not about minor details. They were about the most significant events that allegedly took place, according to her story. This is not a credibility contest about tone or interpretation. It is a comparison between her dramatic but false sworn statements and the objective video evidence and consistent testimony by other witnesses. What makes this case particularly troubling is not merely that Judge Nance's sworn statement was false. It is that her account has changed again and again over 6 years. Each time the evidence cornered one version, she created a new version. That is not fading memory, that is adaptive storytelling. At her July 2020 sworn statement, Judge Nance categorically denied that Judge Brew accused Mr. Green of attacking an African-American judge. She did not hesitate. She did not equivocate. She did not say that she could not remember. Again, she never said that she could not remember. She stated repeatedly that the words African-American were never used. Yet the video review, lip reading evidence, and the testimony of other witnesses demonstrated that Judge Brew did invoke race. The evidence is clear that Judge Brew did claim that Mr. Green had assaulted her. There is not evidence that remotely suggests that Judge Brew ever indicated that she felt assaulted, as Judge Nance claimed. Judge Nance made that claim to try to keep the commission from learning what was really said. Judge Nance was standing right next to Judge Brew when Judge Brew was exclaiming that Mr. Green had assaulted her. She was standing right next to Judge Brew when Judge Brew stated she was absolutely a judge. Judge Nance was right there. Put yourself into this situation for a moment. You're a judge. You know that judges are held to a higher standard, and you just heard your judicial colleague falsely accuse a man of assault and tell him that she was an African-American judge. Those are very inflammatory things for a judge to say. They are not things a fellow judge would easily forget. Judge Nance was insistent when she first testified, but once she was faced with the evidence that contradicted her, she retreated. She claimed that she may not have heard the reference to Judge Brew being an African-American judge. She may have turned her body away, that she may have read her own face years later and concluded that something must have been said. Her explanation evolved into a remarkable claim that in 2023 or 2024, years after her sworn denial, she watched herself on silent video and read her own facial expression to conclude that she must have heard the words African American. This commission must ask, is it credible that a judge emphatically denied under oath that her judicial colleague made a racial allegation that her colleague clearly made? Is it credible that she did so while falsely injecting race into the encounter herself? Is it credible that she maintained her denial in pleadings and only years later, and when it became clear that the evidence disproved her other claims, that she discovered the truth by studying her own facial expression on mute video? Or is it more plausible that the initial sworn denial was false? Judge Nance admitted that at no point between September 10th, 2021 and late 2023, 2024, did she go back and review her responses to determine if there was anything that needed to be modified, even though she was aware that she was under investigation for or charged with making deliberately false statements about these events, as noted in count 2 of the complaint. Yet she supposedly did this for the first time while preparing for the public hearing in this matter. Judge Nance could have corrected her statements at any time. She could have admitted what she newly recalled at any time. Judge Nance could have told the truth at any time. She did not do that. She did not do that because she was creating the narrative as time progressed and as the evidence closed in around her. Perhaps the clearest evidence of her dishonest account concerns Officer Hardy. In her sworn statement, Judge Nance repeatedly volunteered that Officer Hardy refused to speak with them and would only talk to Mr. Green. She was very upset during her sworn statement that Hardy had refused to speak with them. Judge Nance was charged with lying repeatedly about whether or not Judge Nance and Judge Bruce spoke with Officer Hardy. That was not a minor part of her story. Disciplinary counsel cited on pages 21 and 22 of their objections the 10 or so times that Judge Nance emphasized this false claim. Officer Hardy refused to speak to them was central to her narrative. It supported her claim that they were dismissed, that they were treated unfairly and discriminated against, that they were the victims of the interaction on Mackinac Island and not Mr. Green. Judge Brew could not have told Officer Hardy that Mr. Green assaulted her if he didn't speak to them. Judge Brew could not have told Officer Hardy that she was a judge if he didn't speak with them. But the video shows Officer Hardy speaking with Judge Nance and Judge Brew for more than 10 minutes immediately upon his arrival. He stood directly in front of them. They did the majority of the talking. Mr. Green participated occasionally and briefly. And after reviewing the video inside the shop, Officer Hardy again spoke with the judges for more than 10 minutes, explaining what he saw. Yet, Judge Nance denied that he spoke with them. That was not ambiguity. That was not weak memory. That was an entirely false narrative. When confronted with the video evidence that disproved her false narrative, Judge Nance's narrative softened. It then became, he did not fairly listen. Her initial statements were not meant to be literal, but rather colloquialisms. She was really just trying to say that Officer Hardy was dismissive. But that is not what she said under oath. She said that he refused to speak with them. The neutral excused all Judge Nance's false statements, claiming that Officer Hardy did not speak with the women. The sole basis for the neutral to accept Judge Nance's false description of the encounter is that Mr. Green was in the vicinity when Officer Hardy spoke with Judge Brew and Judge Nance. And only Mr. Green was present when Officer Hardy reviewed the video of the supposed assault. But there's no plausible way that Green's sporadic presence could have honestly caused Judge Nance to think that Officer Hardy had not spent a considerable amount of time with both she and Judge Brew. The objective record proves that Officer Hardy spoke with the women at length, and Judge Nance knew that he did, and yet she chose to lie about that to the commission. Another significant shift concerns the allegation that she and Judge Brew were told to wait by the curb. During earlier stages of this case, Judge Nance portrayed the alleged command as humiliating and racially charged. It was offered as further evidence of the supposed disrespect she and Judge Brew received from the bike shop and the police on Mackinac Island. During her July 2020 statement, Judge Nance mentioned the command and went on to discuss for approximately 3 pages the way that such a command made her feel. Judge Nance stated that she felt an overwhelming sense of dread, that she could envision Black people standing at the curb with horses while white people were inside at the business. Judge Nance further stated that she and Judge Brew discussed the feeling that they were being treated like 2 runaway slaves. This explanation was meaningful to the racism claim that was being conveyed. Yet at the hearing, Judge Nance testified that there was nothing improper about being told to wait by the curb, that it was a normal police command. This is a striking reversal. What was once evidence of racial indignity became ordinary police procedure. The only thing that changed over 6 years was the evidentiary pressure. Despite the dramatic switch in Judge Nance's story, in fact, despite the drastic changes to several parts of her story, despite the lack of credibility evidence that anyone told the judges to wait by the curb, despite the evidence that showed that they did not wait by the curb, and despite the affirmative evidence that no one told them that command, the neutral erroneously concluded that a preponderance of the evidence did not show that Judge Nance knowingly and falsely claimed that Officer Hardy told her and Judge Brew to wait by the curb. The neutral was wrong. When Judge Nance made up that story, it was an important part of her claim. It was an important factor that she was the victim of racism. That's why she said it, but it never happened. The video shows Judge Brew grabbing the receipt. Immediately after, Judge Brew falsely accused Mr. Green of assault. She stated that she feared for her life, she invoked race, and again, Judge Nance stood right beside her. And she looked at her as she did so. Judge Nance did not correct Judge Brew's false allegation. Later, under oath, she denied that Judge Brew accused Mr. Green of assault in the presence of Officer Hardy. The video and testimony establish otherwise. One of the most revealing aspects of Judge Nance's testimony is her claim that she and Judge Brew disagreed immediately after the incident. For the first time during the public hearing, Judge Nance testified that they did not see the events the same way. This is a significant detail. The detail was not stated during the sworn testimony. This detail was not stated in any of the pleadings. This disagreement was not mentioned until her testimony during the public hearing. Yet, she could not articulate what they disagreed about. That assertion serves a purpose. It attempts to distance herself from Judge Brew's misconduct. More importantly, without specifics, her newly recollected memory could not be challenged. It could not be contradicted. But it collapses under scrutiny. If the disagreement was meaningful, she would have remembered its substance. The very essence of the introduction of this claimed disagreement underscores a lack of credibility by Judge Nance. This commission must view the gravamen of misconduct in its full context. In 2019, we have the incident. In 2020, the sworn statement, where we have emphatic denials. In 2021, we have written responses. There's a partial retreat. In 2023 and 2024, we have claimed epiphanies. And in 2025, during the public hearing, we have a reframed narrative. At each stage, the story adjusted to the evidence. That is not memory decay, that is litigation strategy. A judge cannot treat sworn testimony as provisional. The commission must determine whether the misconduct has been established by the preponderance of the evidence. When Judge Nance's emphatic and dramatic volunteered sworn testimony is contradicted by video and nearly all other evidence. When denials shift after exposure, inflammatory race allegations are made and then diluted, and officer conduct is mischaracterized. Once the narratives continuously change, that burden has been met. Under Brown, the commission considers the nature and seriousness of the misconduct. Dishonesty under oath by a judge is among the most serious forms of misconduct. The commission has to consider whether there was a pattern of behavior or whether this was an isolated incident. This was not a single slip. It was a series of false statements maintained over years. The falsehoods were emphatic and volunteered. The impact on the judiciary is that public confidence depends on judicial truthfulness. Whether or not there has been any remorse or acknowledgement, there has been no genuine acknowledgement, only evolving explanations. Then the commission must determine whether or not there's a likelihood of recurrence. Without acknowledgement of wrongdoing, the risk remains. These factors weigh heavily toward removal. The public must believe when a judge raises her right hand and swears to tell the truth that the oath means something. If a judge can deny what is plain as day on video, tell the same false stories as another judge, maintain those denials for years, modify them only when forced, and implausibly characterize that evolution as refreshed recollection, then the oath loses its meaning. Judicial authority depends on credibility. Credibility, once lost, cannot be selectively restored. Removal is not punishment, it is protection. Protection of the integrity of the judiciary, protection of the public's trust, protection of the meaning of the judicial oath. If persistent dishonesty under oath does not warrant removal, it is difficult to imagine what would. Accordingly, disciplinary counsel respectfully asks that the commission recommend removal of Judge Debra Nance from judicial office. However, if the commission concludes that removal is not appropriate, disciplinary counsel urged the commission to find a sanction that unmistakably reflects the egregious nature of this misconduct. The sanction must communicate clearly that lying under oath is incompatible with judicial office, that infusing race into a dispute and then retreating from that claim is misconduct, and rewriting sworn testimony over 6 years is unacceptable. Anything less risks signaling that judicial dishonesty carries no meaningful consequence. Thank you.
Thank you. You have 5 minutes. I'm going to now turn to the commissioners. Any commissioners to my right who have any questions?
No question.
All right. Any to my left?
No.
No, seeing none. All right. Thank you very much. You have 5 minutes rebuttal and we'd like to hear.
Oh, okay.
Okay. Yes, go right ahead. Judge Nance, I understand you're going to be arguing today. Okay, go right ahead, please. Yeah, absolutely.
Oh, yeah.
Go right ahead.
I've looked forward to this moment for a long time. I'm not happy to be here today, but I've looked forward to an opportunity to address this body. I stand before you today like any other citizen with a constitutional right under 28 USC 1654, Section 1564, to represent myself. I made an appearance in pro per on November 1st, 2023, pursuant to the court rule at MCR 2.117. My attorneys here, are here today. I'm happy that they've joined me, Mr. Nicholas Serino, Mr. Michael Cafferty, who are seated, who join me today for support. However, I remain in pro per. I firmly believe that I cannot stand up for the rights of anyone in my courtroom if I cannot stand up for myself. And believe me, I am well aware of the often repeated axiom, a man who represents himself has a fool for a client. Aware. I recognize that standing here before you today may be considered by some to be foolish, even risky, but I want you to hear directly from me. I have presided in the 46th District Court for 13 years. I'm in the 3rd term on the bench. I reside over 5 suburban cities in Oakland County, Southfield, Lathrop Village, Beverly Hills, Bingham Farms, and Franklin. I hear civil cases, I hear criminal cases, landlord-tenant matters, I hear small claims appeals. I'm a member of the National Bar Association, the Judicial Council, a former member of the Executive Committee. I've also been former president of the Association of Black Judges of Michigan. I serve as a committee chair for the National Association of Women Judges. There was an international conference here. And for 5 years, I hosted and produced a radio show in which Your Best Chance with Judge Nance, if you can imagine, in which I brought in attorneys and lawyers to talk to the public weekly about legal issues. I'm an advocate for educating the community on various topics. I love the law. I'm an advocate for it. And in 2021, I received the Joan Young Award for Judicial Excellence that was awarded to me by the Women Lawyers Association of Michigan, Oakland County Division. And for my service on the bench to the bar, attached to the pleadings was a bio, and that information is also on my website. When the JTC filed its formal complaint and sent it into the newspaper, on that same day, I issued a press release that was picked up by the Oakland County Press. I did not discuss the merits of the case, but I found it necessary to tell the public unequivocally that I had done nothing wrong, that I had no history of misconduct. And I say that to you unequivocally. There is no meetings that I've had with anybody about anything up until I met with the investigators when I was called in to testify in 2020. Despite the years of negative publicity and salacious headlines and the inaccurate, very inaccurate reporting, my community rallied and supported me. I won my third term in November 2024. On a personal note, I am extremely proud, and I don't shy away from telling anyone that I'm first-generation college graduate. My grandfather had a third-grade education. My parents graduated from high school. It was never a question as to whether I would graduate from college. But my dream was to be a lawyer, and becoming a judge was beyond my wildest expectations, just beyond my wildest expectations. There is absolutely no reason on God's green earth that I would risk my reputation, my good name, and my livelihood and a job that I love to go in and intentionally make a false statement to the Judicial Tenure Commission. Initially, it was said that I was lying to cover up for my colleague, the Detroit judge, who I had only known for 2 or 3 years prior to this event. Didn't know her before I became a judge. Was not related to her. We were not personal friends. We were colleagues. We were friendly. We didn't celebrate each other's birthdays. We didn't shop together. I've never been to her home. She's never been to my home. I've never gone to any of her family events. She's never come to any of my family events. We weren't friends in that fashion. And those of you here today, you know exactly what I'm referring to. There are people you know from work that you are not personal acquaintances with in that fashion. Why would you put your name and your livelihood on the line or risk saying something untrue just to cover for that person? As a judge, I'm only responsible for what happens in my chambers. I'm responsible for the actions of my staff. I am not responsible for the actions of another adult person. There's no reason for me to have made an untrue statement. Now, because I've done nothing wrong, I'm not willing, as some judges who've been accused of misconduct have been, I'm not willing to hide my face or not attend events or not show my face in the community. I keep my head up high. I've done nothing wrong. I'm not willing to quietly resign my position and just go away due to the embarrassment and the humiliation of these false accusations, like some have done. But as all of you know, not everybody charged is guilty. Please, we have to remember that in this country. But so often people do go away, just quietly quit and resign due to the weight of the allegations. I have not, however, been willing to yield or break under that weight or the pressure that I feel for the last 6 years, like David versus Goliath, because this agency has the absolute power. I've asserted my rights because I have done nothing wrong. Now, Ms. Hord's statements today were very difficult to listen to, as you can well imagine. Ms. Hord speaks today on behalf of disciplinary counsel, and she speaks in place of the executive director. It's my understanding that typically the role of the executive director, it would be that person's role here today to represent disciplinary counsel in these proceedings. This case is unusual because the executive director just happens to be my grievant. He is the person, former executive director, I should say, who personally brought the charges against me to the commission, not anyone on Mackinac Island. Mr. Green wanted to file a complaint, filed a complaint against the Detroit judge. He could have filed a complaint against me. He did not. I have not been the victim of a complaint by anyone on Mackinac Island, any litigant in my court, any attorney in my court, any member of my community or any other community until this situation. On January 30th, I understand, 2026, the executive director made his untimely departure from employment by the JTC. So it is Ms. Horde's role to stand here before you today. And it's interesting because of the 4 attorneys that have been on my case for the last 4 or 5 years, Ms. Horde is the last man standing. Of those 4 attorneys, 3 of them are no longer serving at the pleasure of the commission for whatever those reasons might be, but I'm still here. But one of the most interesting things about Ms. Horde's presentation today is that I don't personally think that she believes any of the things that she said to you. Could be wrong. Now, I recognize that Ms. Horde must put food on her table like everyone else. And I do want to acknowledge that Ms. Horde has been gracious and professional towards me at every juncture. In fact, she's treated me with the level of courtesy and respect that, in my opinion, depicts that she's simply just doing the job that she was hired to do. In fact, Ms. Horde was not a member of this agency when this investigation launched. She was not, had not yet been hired by this agency. When I was in that room in July of 2020 testifying, she has no firsthand knowledge of the facts for which she speaks. There's a lot of information that's been shared with you this morning that's totally incorrect. If you were to read my sworn statement, which I hope all of you have done, I absolutely acknowledged in July of 2020 that there were reverse allegations of assault. Piece of paper, rental receipt, happened to belong to Judge Brew. She took it out of her bag. There was this interaction over this paper receipt. And at the end of that interaction, the paper receipt was ripped. And I said to the commission, the investigators, that at the end of that, they both were accusing each other of assault. Judge Brew said, I feel like you assaulted me. And Mr. Green said, you assaulted me. At that point, I'm shaking my head because we simply wanted to pay and leave. And now this has come into dual allegations of assault. I stated that to the JTC. It is in my sworn statement. I also at that time indicated to the JTC that there had been an introduction as a judge. When the trooper who came along and resolved the situation in moments walked up, I thought at my phone call, because I did call for a supervisor, Judge Brew then turned to him and introduced herself. I'm Judge Demetria Brew, and she turned and began to say, and this is my colleague, and my eyes went big, and she simply said, from another jurisdiction. I did not want to be introduced as a judge. I don't introduce myself as a judge. I don't even tell people unless it is a bench or bar gathering, then I'm even a lawyer, because then people start to ask for free legal advice. Being a judge had nothing to do with what was happening at that bike stand. It was my belief that she introduced herself as a judge because that was probably going to be a question from him. Who are you and what are you doing here and what's going on? So she said, this is who I am. I have heard the testimony today, or the argument from Mr. Thomas, who believes that I am now the one who said to these people that she was a judge. I have no reason to tell those people that she was a judge. I didn't want anybody to know I was a judge. not sure where that comes from, but it's there. What's happened during this case is that there's been this strange intermingling and twining of testimony of who said what to whom and when, and it has gotten totally distorted. My case, however, still continues into a 6-year. You, however, your role is different from Ms. Hord. Ms. Hord is doing her job. You, however, have volunteered for this position. You have the absolute freedom, the unfettered power and authority to do justice. You accepted this role because you have the courage to do the right thing and the wisdom to know that it's never too late to correct an injustice, to correct course, so to speak. Course correct, it's now called, to adjust direction, to fix a problem, to alter a plan, and to get the overall mission back on track, because this has gotten totally off track. When I was a student at Wayne State University Law School, I remember attending a packed auditorium, crowded. There was going to be this prosecutor who was going to speak, and everyone was going to this presentation. And the person who spoke about the important role of the prosecutor and what a prosecutor, that role, how it was played out in the courtroom. And many of my fellow law students all wanted to be defense attorneys because we all wanted to seek justice. But when this prosecutor spoke about the opportunity for a prosecutor to have the ability to do justice on behalf of the people, I was so impressed with that role. I was impressed with that. So after the presentation, I fought my way up to the front of the auditorium and nearly begged to be interviewed for a position, an interview with this prosecutor. And the person that has spoken to me this morning tapped me on the shoulder to let me know she was here, was Nancy Deal, retired chief of trials in Wayne County Prosecutor's Office. She was a presenter that day, and she may not even recall how our paths crossed, but I was honored to do an internship under her and practice as a student. I was so proud when I got an opportunity each and every time to stand and introduce myself and ask to practice under the court rule at MCR 8.120 and had the ability to do the right thing on behalf of the people. But when this, and I actually heard motions and did trials, conducted trials, PPO violators. I don't speak to Nancy. We don't have a relationship, but when she heard about this case, she contacted me. And she reminded me that when she trains prosecutors, as she has for dozens of years, she cautions the prosecutors that they will probably become very entrenched in their cases, but to realize that they might be doing so because they have blinders on. But she tells them to take off those blinders, and she trains them to listen carefully to the defense perspective that just might reveal a reasonable and a legitimate alternative to what's occurred. She educates them to be aware of the human instinct of confirmation bias, which is that unconscious tendency to seek and interpret only those things that validate our pre-existing beliefs. And she reminded me, her prosecutors, to always be willing to reevaluate the charges. And one of the most important things she says is that one of the most important things you can do in the legal profession is to admit and acknowledge when you may have gotten it wrong. So I share that with you today because while disciplinary counsel does the upfront work, you indeed are the prosecutors here today. You are the ones that will make the ultimate decision as to what really happened here. So I ask you to see this from a new perspective. I ask you to open your eyes to the possibilities of the alternative, legitimate explanations that I'm going to share with you today. It's been a long time in coming, as I said. The circumstances of this case, again, are worthy of distinction. You've had a long morning, so you've heard about the other case. As Ms. Horde has respectfully brought to your attention, this is a separate case. This is something totally different. And FC 105, the charge originated on Mackinac Island during a judicial conference. 2019, a bike vendor had a dispute with a colleague that I went on this bike ride with, thinking that we were just simply going to relax after a long day of conferences. I, however, was called a year later, and we walked away at the time, again, thinking that the incident was resolved. They shook hands, Mr. Green and Judge Bruce shook hands. We walked away, went back to the conference center. It was over. I was contacted a year later, picked up the phone in my chambers, and I'm talking to suddenly an investigator from the JTC who tells me that there's been a complaint filed against the Detroit judge. I was a witness to the event, and I was required to come in and testify only under oath. I volunteered to answer questions on the phone. Well, but what can I tell you? Yes, I remember the incident of the dueling, who ripped the paper and who assaulted who. No, Judge. We want you only under oath. So, as any reasonable person would do, I've got to be under oath. I hired an attorney and asked my attorney to represent me at the sworn statement. Actually, it was an interview under oath, and asked him to reach out and get the video that I knew existed, the surveillance video. Help me refresh my recollection. I don't want to testify inaccurately, would never be untruthfully, but I don't want to testify inaccurately under oath. My attorney asked for the information. It was denied. I then had him send a letter. Please request that I be given something to recollect my recall, refresh my recall. Denied. When I arrived that morning, because even though I'm not under subpoena, I still know I have a duty to participate in a JTC request. So I did, cold, no information, didn't know what they were going after, didn't know exactly what the charge was. In fact, Judge Brew didn't know anything about the complaint. I get there that morning, they show me 1 minute and 39 seconds of video, which was the ripping of the receipt, to direct my attention in that direction. And then for nearly 2 hours, they asked me every question under the sun about what 4 to 5 other people did, what they said, when they said it, where they stood, how long they stood. And then the focus came to answering or repeating several express specific statements that apparently the vendor said that the judge said. Not that I said, but what specifically did the judge say to the vendor? So I was being asked to repeat express statements that I could not recall and dared not to repeat under oath. Had no idea whether I was being even told the right statements or the wrong statements. Couldn't repeat them. So my case, and I'll give you the specific allegations very quickly because they're very short. I am accused of having lied about whether Judge Bruce said to Mr. Green, I am in fear for my life. Whether Judge Bruce said to Mr. Green, I am in fear for my safety. Whether Judge Bruce said to Mr. Green, African-American female judge. Out of all of the information that I did give them, I could not attest to these expressed words. And I knew better than to raise my hand and say, yes, I remember that. Yes, that's what she said. because I didn't recall or know if that's what she said at all. The other two issues that I've been accused of is that Officer Hardy, based upon the video, spent exactly 10 minutes in our presence. 10 minutes from the year before. Officer Hardy, when he approached us, in my opinion, appeared to be a bit dismissive. He did not appear to really take in or engage with Judge Brew as she was explaining to him what happened. As a result, I went back and spoke to Mr. Green. I thought that maybe he was the person to really resolve this with. I later figured out at the trial, when I watched Officer Hardy testify, that perhaps Officer Hardy, who testified with a very flat pan expression, he did not focus. He appears to be looking a little bit above the speaker. I don't think that what I perceived as dismissiveness was actually Officer Hardy being dismissive, but that was my perception of him when I testified a year later. The person that I accurately recall was the trooper, because when he came in, he spoke to Judge Brew, he listened to her, and he had it figured out within minutes that this is a simple customer dispute. He's the individual that I recalled. I used the words that Hardy blew us off. Blowing someone off, that colloquialism does not mean that they didn't stand in your presence for 10 minutes. It means that I felt by Officer Hardy that I was not seen, that I was not heard, and the few statements that I made to him, he didn't really appear to be engaging with me. So I used the expression, he blew us off. However, the commission has indicated that that constitutes, in their opinion, a lie. The last allegation is whether we were told to stand and wait at the curb. We were indeed told by Officer Hardy when we were asked to leave the bike environment because they went in to watch the video. We went behind them to watch the video. And what are we watching the video about? Whether there had been an assault by Judge Brew towards Green, or whether there had been an assault by Green towards Brew. Yes, I acknowledged to them that there were these dual reports of assault. I was specifically asked, if you can check my sworn statement, whether I saw any assault. And I said to them, I didn't see anybody assault anybody. I didn't see an assault on behalf of Brew. I didn't see an assault by Green. But Judge Brew said that during this paper exchange, you scratch my finger. I feel assaulted. Grown woman says she feels assaulted. I tell the JTC that a grown woman says she felt assaulted. If I witness a crime as a judge, I have a duty to report it. I didn't see a crime by anyone. That was my personal opinion, my perspective, and I shared that freely and openly with the JTC. But what's more important here today, it's not the information that Ms. Hort is trying to tell you, because the facts are totally confused. I think what is important for you to know is what they don't want you to know. They do not want you to know, for example, and I will repeat once again, the special master said the bottom line here is that Judge Nance was put in a position to remember details of an event she wished and thought were over. She did not intentionally falsify testimony. Now, what I want you to know is that there's no law to support the charge against me. Disciplinary counsel had no witnesses at my trial because they have no witnesses. They have no witnesses as to direct intent. They have no circumstantial witnesses against me. The only person who could have been a witness at my trial was the executive director, because it was his opinion in July 2020 that brought about the charge that what my statements were constituted a lie. Well, I put him on my witness list. I wanted to have him testify to that. What did I do? How did I act? What was my behavior while testifying under oath in July that led him to the conclusion that I lied under oath? Well, he refused to testify. He hid behind the shield of the JTC, and he says, the commission authorized it. I have nothing that I could offer.
I just want you to know you've got about just a couple more minutes.
Thank you. I'll get there very quickly. So there was no witness. So what simply occurred in my trial was that disciplinary counsel marched in the exact same witnesses in my case that they marched in the case before. None of those people were in that cramped room in Grosse Pointe when I testified. None of those people could testify as to what my frame of mind was or any intent to lie a year later in July. And so there were no witnesses. But also more importantly, what they don't want you to know, and I'll just say again, inferring intent, and I've got it, the legal authority right here. Ordinarily, there is no way that a defendant's state of mind can be proven directly because no one can read another person's mind and tell what that person was thinking. But a defendant's state of mind can be proven indirectly from surrounding circumstances. This includes things like what the defendant said, what the defendant did, and how the defendant acted while giving testimony or while the defendant was conducting this misconduct or while this offense occurred. The only person, again, who could have informed anyone of that is my grievant. But my grievant, the executive director, refused to testify and just marched in other people who had no knowledge of anything that I testified to a year later. There's all kinds of information on memory. Human memory is not like a video recording that a witness can simply replay to remember precisely what happened. People see and hear things differently, and a witness may testify honestly, and you all know this as the jury instruction, but simply be mistaken about what they thought they saw or remembered. So why was this happening? And there was never an explanation for it. I did not know why I was being picked up and brought into this case and made virtually a co-defendant or a co-respondent. There were numerous efforts to try to combine both cases. And I started to ask myself, why? Why was it so important to make me a co-defendant? Why couldn't I simply have been another witness like the witnesses on Mackinac Island to the actual complaint that the bike vendor filed against Judge Brew? Let the trier of fact determine whose credibility or whose testimony the trier of fact wanted to decide. But the more I read as to in the pleadings, the more it became clear to me. There is actually a pleading in which, in my case, it was a response to the supplemental motion to dismiss, where disciplinary counsel says Judge Nance claims her statements are immaterial and frivolous because what is all of this about? I didn't remember 3 sentences that Peter said, that Mary said, but the pleading goes on to say it was important to the Judicial Tenure Commission investigation of Judge Brew to get accurate picture of the events surrounding Judge Brew's alleged abuse of her office when she interacted with Mr. Green and the employees, and when Judge Brew allegedly made false statements to Mackinac police. That's why I'm here. My case is about Judge Brew's case. And apparently, the pleading then goes on to state, Judge Nance construed a narrative that intended to exculpate Judge Brew, or at least mitigate her actions. Judge Nance's narrative, if believed, would at minimum damage the credibility of the other witnesses in Judge Brew's action. Now, I don't know whether this was a slip of the tongue or a slip of the pen or a slip of the stroke, But here in my pleadings, disciplinary counsel explains why I was so important. Because I was important to the Judge Brew case.
And that's, we've pretty much gone about almost 35 minutes, but I appreciate it. Anything further?
I just ask you to keep your eyes open, keep your ears open, read the pleadings. These cases have been so twisted together. I have never, ever used the words racist, racism, or discriminate. Now, while Judge Brew may have taken that position, I don't know what's in another man's mind. I don't accuse anyone of any of those things. I never said those words. Those words have been attributed to me. The things that were said by Ms. Hoare today, those are disciplinary counsel's perceptions of what they think I meant to say.
Let me interrupt for a minute. Let me ask.
Yes, sir.
To my right, any questions from any of the commissioners to my right?
Please ask a question.
Yeah, I think Judge Lillard, I think, has a question or more.
Judge Nance,
Yes,
did
Judge.
you not indicate in your original statement that you felt as if you were being treated as if you had escaped from the Grand Hotel, which with the category, with the understanding that the majority of the domestic staff at the Grand Hotel are Black,
Yes.
and that they were treating you like you had escaped from the Grand Hotel? And does that statement not imply, and I'm talking about your original under oath testimony, does that statement not imply that you felt as if there was some sort of racial animus?
I thank you so much for asking me that. Judge Lillard, when we walked into the bike shop to all review the video, Mr. Green, Officer Hardy, I'm behind Hardy, Brew is behind me. We get to the back of the shop to review the video all together, and Judge Hardy turns to me and says, "Get out. Get out. I thought we were here to watch the video." Hardy says, "No, he does not want you here. And if you don't leave, you're trespassing." And there is a document in your exhibit book where he says that he told me that. When we were instructed to stand at the curb, I says, "Well, get out where?" He says, "Right there." Right where? At the curb. I knew then that we were being detained. Detained. I had not been accused of this cross assault issue, but I also had to stand and wait while they reviewed the video. So there's an investigation going on. The words that I shared at that interview with disciplinary counsel were the words that I uttered to my colleague, to Judge Brew, as I stood on Mackinac Island, the land that time forgot, where there are no cars, no traffic, there's just the clump of horses. I said to her that I was having a recollection because I couldn't move. I knew I couldn't move. Direct command by a police officer in uniform. If I had even tried to move, I could have been charged with resisting and obstructing. Because I had to stay there, and I had never had that experience before in my life, where I have not been able to walk about freely, where I have not been able to move, where I've not been able to stand back out of the shade, I expressed to Judge Brew privately how I felt in that moment of being detained. And I see video every day in my courtroom, and the words "stand at the curb" are often used. That's protocol for police officers. But I also know that the next step after their investigation is that you're either going to be told, "Okay, we've looked into it, we've resolved it, you're free to leave," or you're coming with me. I have never been that close in my life to being arrested, and I had never been detained. And so I'm giving her my present sense impressions of not watching cars and vehicles, but watching horses go down the street, a dusty road, there's horse dung, I can't move, I'm in the hot sun. And I get this present sense recollection of what it must have been like for my ancestors 200 years ago while waiting with the horses. There were horses in front of me. What it must have been like not to be able to move. That is when I pulled out my phone and called 911. I wanted to have a supervisor at the scene. I wanted another set of eyes. That's what I've been told you do. The standing at the curb, that's police language. I hear it weekly. I had never been told to stand at the curb. That's what
Nance,
told
my
me I was being
question to you
detained.
Was about escaping
Yes,
from
I
the
said
Grand
that.
Hotel.
I had all of those impressions. When Officer Hardy turned to me and said, "Get out, he doesn't want you here," I had not heard Mr. Green say anything. So my first impression was, when did he say he didn't want us here? I got the distinct impression that there had been other situations where Mr. Green perhaps did not want people inside, and somehow Hardy knew this and said it. I knew that the majority of the people might have, I didn't see a lot of traffic of people who looked like me on the island that particular time. And I knew that there were a lot of people who worked in the Grand Hotel who were from Jamaica or some of the islands who came over for the summer to work. Maybe on their off days, there might have been some problems or some confusion. And I didn't know why I was being told to get out. Why get out, even in those words? Not, "Ladies, do you mind stepping outside? Mr. Green doesn't want any customers inside." It was, "Get out. He doesn't want."
Any other further, gentlemen, nothing? Any follow-up at all on that? All right, thank you very much, Judge.
I'm
And we're
just-
going to turn it over to the other side for 5 minutes of rebuttal, but
Thank you, Judge. I'm just
But-
simply asking you to course correct here today. There's been a miscarriage of justice, in my opinion, in my case. Thank you.
thank you. Sword, you have 5 minutes. All right, thank you very much. That concludes the hearing. Thank you all for being here. That concludes the hearing. Thank you.
All right. Thank all of you for your time.
Thank you.